318.
Good morning, Your Honor.
Good morning. Good morning.
Morning, Your Honor.
Good morning, Your Honor.
Morning.
Morning, Your Honor.
You know, they're probably going to need some chairs.
We'll grab them.
I think you might be there for a few minutes, so I don't want everybody standing.
Send some down here.
And then okay. Because I know there's a 9:30, but do the parties want to start making their appearances?
Yes, Your Honor. Maggie McLetchie for Steve Sanson, who's here with me in court, and Veterans in Politics International.
Cal Potter on behalf of Louis Schneider, who's also present.
Good morning, Your Honor. Joshua Gilmore on behalf of Plaintiff.
Marshal, Willick 2515 also on behalf of the defendant. Sorry for that.
That's okay. Everybody's got something. Jennifer Abrams. Good morning. Good morning. Before the parties get started, I just want to make sure one of the attorneys in this, and I think he's an attorney with Miss Abrams' firm, his name is Brandon Leavitt. Because his name came up so much, I did a inquiry to see. He is not related to me, at least within the third degree of consanguinity. I was not familiar with him. I don't think I've ever met him. So I asked some other family members, and I can tell you he's not related to me within the third degree of consanguinity. I'm happy to answer any questions if anyone has any questions about that. It appearing nobody has any questions, I just wanted to make sure that that was disclosed in the beginning. So I want to start with the special, I'm sorry, you looked at...
Just one housekeeping matter, Your Honor.
Sure.
Mr. Giabato, you know, is not here. We resolved the claims against his clients on Friday afternoon. We apologize we could not get a stipulation in front of you in time. Those would be the Hanusa defendants, as they were called.
Okay,
So
so all the directors.
Correct. So it's,
Okay.
at this point, it's just Mr. Sanson, Vippy, Mr. Schneider, and his firm are the remaining defendants.
Okay, so that takes care of one motion. So I think we should, obviously procedurally, we need to start with the special motions pursuant to the anti-SLAPP statute.
Thank you, Your Honor. Sorry for left here. Your Honor, Veterans in Politics International is a public government watchdog, including of the courts. The statements at issue in this case were made by Steve Sanson in his capacity as its president. His statements were matters of opinion, which as a matter of law are not actionable as defamation, and are also, as a matter of law, protected by the First Amendment and Nevada's anti-SLAPP statute. This case is a transparent attempt by an attorney to do exactly what anti-SLAPP lawsuits were designed to protect against: abuse litigation to impose financial burdens to silence criticism. Ironically, one of the things Ms. Abrams is suing about is being called a bully. Yet, if whether or not she were a bully weren't a matter of opinion, she has proven characterization to be true by filing her baseless kitchen sink lawsuit with 11 claims and over 40 pages. But this case, despite the fact that the amended complaint is very long, essentially, in my view, boils down to two questions. Are proceedings and conduct in taxpayer-funded courtrooms private? And second, does criticizing attorneys for being overzealous and questioning whether an attorney adheres to ethical standards subject a member of the public, a member of a watchdog group, to liability? While plaintiffs are contending that they have a privacy interest in connection with their courtroom behavior and that they can sue for criticism of how they interact with judges, commentary about judicial proceedings, in fact, goes to the heart of what the First Amendment protects against. It's well established that citizens have a right to access courtroom proceedings. For example, in recognizing the fair report privilege, the Nevada Supreme Court has said Nevada citizens have a right to know what transpires in public and official legal proceedings. Yet, plaintiffs would have you believe that they should be able to subject Mr. Sanson and the nonprofit he operates to financial ruin because he dared to say that he believed that Ms. Abrams keeps too many family court documents sealed from public view, for example. I'll also note for the court that, cloaked by the protection of the litigation privilege, rather than focusing on the legal issues at hand, in many ways plaintiffs have asserted numerous falsehoods without any factual support. And while on a 12b5 motion to dismiss, they don't need to have evidence, on a special motion to dismiss, they absolutely do. With regard to the anti-SLAPP motion, the VIP defendants have met their burden, the first prong of the anti-SLAPP analysis. As I already mentioned, it's well established that opinions are not actionable and can't be proven true or false. Other than posting a video in its entirety, which can't possibly be defamatory, the statements at issue are all opinion, all protected by both the First Amendment and the anti-SLAPP law. Attorneys disagree about whether documents should be sealed, whether behavior is unethical, whether someone is engaging in criminal conduct all the time. Citizens are also entitled to do so, even when they disagree with attorneys. To the extent that the statements pertain to how Judge Elliott should have ruled in the Sater case, the underlying family court case at issue, or how Judge Elliott should have controlled Jennifer Abrams or reported her to the state bar, the statements all actually fall squarely within NRS 416.373, which says that defines an example of a good faith statement, communication protected from a SLAPP lawsuit as written or oral statement made in direct connection with an issue under consideration by a legislative, executive, or judicial body or any other official proceeding authorized by law. Then, all of the other statements, the statements about Ms. Abrams, all fall within the fourth prong. They're communications made in direct connection with an issue of public interest in a place open to the public and in a public forum. Plaintiffs argue that because Sanson didn't assert that the statements were objectively true in his declaration, he did submit an extensive declaration with his special motion to dismiss, that he can't meet this burden because the law requires you to establish that the statements are either truthful or made without knowledge of their falsehood. However, the statements are matters of opinion, which are of course protected by the anti-SLAPP law. Accordingly, he can't prove something to be true that's a matter of opinion. The Nevada Supreme Court has made this clear, for example, in the Pegasus case. There's no disproving or disproving an opinion. Sanson's declaration, in fact, details that he asserted his opinions about Ms. Abrams in good faith and in the connection of policy questions regarding the conduct of the judiciary. For example, Nevada Supreme Court discussion of sealing records. For example, discussions of whether or not in some instances judges are stepping over the line and whether or not this case is an example of where an attorney stepped over the line and a judge failed to control her. He has met his burden of establishing that he is engaged in good faith communication protected by the First Amendment and Nevada's anti-SLAPP law. If you go through the four key statements at issue, and I think I have copies of them, but they're in their omnibus opposition to the SLAPP motions, it seems like they're focusing on four key things, and I'll go through each of those. There's numerous statements at issue, but the first is Exhibit 1 to the First Amended complaint. Do you have that in front of you, Your Honor? Would you like a copy?
Sure. Well, I have a lot of pleadings, so.
There you go. May I approach, Your Honor?
Absolutely. Thank you. Thank you.
So I'm starting with Exhibit 1 to the First Amended complaint, and it says, the headline says, Nevada attorney attacks a Clark County family court judge in open court. And it says, no boundaries in our courtroom. And in the first page, it talks about, as I mentioned, the conduct of justices of the peace. And then it says, the above are examples of the courtroom overstepping boundaries. But what happens when a divorce attorney crosses the line with a Clark County District Court judge? And then it goes on to say that there was a war of words between Jennifer Abrams and Judge Jennifer Elliott. And there's a link to the video in its entirety. And then there are verbatim quotes. And the focus of these quotes is not whether or not Ms. Abrams' client lied about his finances, which is something the judge did retract at the end. The judge did not retract at the end of that hearing the numerous times in which she asserted that Ms. Abrams was being rude, overstepping her boundaries, and that she and her firm had a practice in family court of filing baseless and vexatious motions. So we have on the third page of this exhibit, I find that there's undue influence in the case. There are enough ethical problems, don't add to the problem. And then she later on says, I am the judge, and in a moment I'm going to ask you to leave. Your firm does this a lot and attack other lawyers. I find it to be a pattern with your firm. You're going to be taken out of here if you don't sit down. I am the judge, not you. And then Ms. Abrams interrupts the judge and says, excuse me, I was in the middle of a sentence. That's on page 4. And then, out of nowhere, she says, is there any relationship between you and Louis Schneider? And there was no relationship. And then Mr. Sanson goes on to opine, at what point, or not even opine, but rather to ask, at what point should a judge sanction an attorney? Is a judge too comfortable or intimidated by an attorney that they give them leeway to basically run their own courtroom? If there is an ethical problem or the law has been broken by an attorney, the judge is mandated by law to report it to the Nevada State Bar or a governing agency that could deal with the problem appropriately. He's questioning her behavior in that courtroom. He's citing to what the verbatim to what the judge said about her behavior in the courtroom. And Ms. Abrams may not like it. And this court may not like it. But Mr. Sanson is entitled to express his opinion about Ms. Abrams' behavior in an open courtroom. There's absolutely no interest in privacy with regard to the behavior in the courtroom. In the Nevada Supreme Court recently clearly adopted a test from California, and that's in the Shapiro v. Willick case, Your Honor. And the factors, for example, are that it explains that there should be some degree of closeness between the challenge statements and the asserted public interest. The assertion of a broad and amorphous public interest is not sufficient. There's a clear link here. Here, Mr. Sanson is talking about questions about conduct in courtrooms. Are judges overstepping their boundaries? Are lawyers overstepping their boundaries? The connection is very, very clear. And we provided to the court, Your Honor, the transcript of that hearing and also cited 2 examples in that transcript. The plaintiffs represent that at the end of the hearing, Judge Elliott retracted all her statements. She retracted her finding that the client had lied about her finances, but she never retracted her comments about Ms. Abrams' behavior in that courtroom. And frankly, the transcript speaks for itself. It does appear to reflect that Ms. Abrams repeatedly interrupted the judge and acted in what a reasonable person, including a member of the public, could find to be obstructionist or vexatious behavior. The second statement at issue, Your Honor, is if you turn to Exhibit 2, I believe, and that's the bully article. And in this article, what had happened is that Judge Elliott had entered an order requiring that the video be removed. In subsequent litigation, they also tried to place Mr. Sanson even behind bars in the family court matter. The family court judge not only declined to hold Mr. Sanson in bars for refusing to comply with her order, she recognized the unconstitutionality.
She lacked jurisdiction.
Exactly, Your Honor. And she found that to be a constitutional issue. And so much like Steve Sanson had done, she said that this order was overbroad and unsubstantiated. Yet, the plaintiffs somehow say that calling that order overbroad and unsubstantiated is a false statement of fact subject to a defamation claim. It just isn't, Your Honor. And again, whether or not someone's a bully, for example, is certainly a matter of opinion. Someone could find Ms. Abrams to be a well-respected, zealous, hard-fighting attorney, and that may very well be the case. But other people could look at the same overzealousness and say, no, that's inappropriate behavior for a courtroom, and I find her to be a bully. So that's the bully article. Then finally, the third main article is this article called Seal Happy. And the argument that this is somehow defamatory really requires this court to say that it's not a matter of public interest whether or not hearings are sealed and whether or not an attorney seals hearings. And the bizarre implication of plaintiff's argument would be that they can seal whatever court proceedings they want, and if a member of the public dares to say, we think you're sealing too much stuff, we want to know what goes on over there in family court, they'll sue you. So even the fact of the sealing somehow has to be secret, which just isn't the case. Then finally, some other statements at issue appear to pertain to a conversation between a paralegal at, I think, Mr. Willick's firm and Mr. Sanson. And it's hard for me to understand how those are possibly defamatory because a plaintiff in this case is Ms. Abrams' law firm. to the extent that her paralegal is a member of her law firm, I don't understand.
Okay,
how,
is the paralegal Miss Abrams or Mr. Willicks? Because I believed it was Miss Abrams.
I'm sorry, it was Miss Abrams.
Okay.
I misspoke. So again, thank you, Your Honor, for providing me that clarification. I misspoke. But there can't possibly be defamation to the plaintiff, right? That doesn't make sense. It has to be to a third party. And so that's entirely unactionable. And again, they're also matters of opinion. And they just haven't met their burden to show that any of these statements fall outside the protection of Nevada's anti-SLAPP statute. They try to make some arguments that because things that were on the website or Facebook were also emailed to some members of...
Right, they make the argument, I believe, that when they were sent through email, that took it out of the anti-SLAPP if it was in it at all, because that's a new publication.
I understand, Your Honor, but I don't see having a specific audience for your public statements that you're also sending that message to as creating some exception to the anti-SLAPP rule. For example, Politico, the New York Times, they all do these newsletter alerts where you can get the news from these publications sent directly into your inbox. To say that those journalists and those publications wouldn't be protected under anti-SLAPP laws because they're also emailing those articles to specific people who say, hey, I want to get a direct communication. These aren't private emails. These are emails that go to membership, to people who say, hey, I want to hear what's going on. And then they're the exact same communications, and so they're still public communications. In any case, Your Honor, as we get into in the motion to dismiss, they also aren't defamation because, again, they're matters of opinion. Their other argument is that because there isn't exactly a case on point almost, it seems to be their argument, that we can't establish that we fall within the anti-SLAPP statute. They try to distinguish cases from California that we rely on that show, look, an attorney's not immune from criticism. There's cases about alerts to consumers, about attorneys, and they say, well, those are really just about protecting consumers, and so there's a real public interest here. There isn't here. Just because those cases dealt with consumer protection doesn't mean that that's the outer bounds of what the anti-SLAPP statute protects against. It also protects against talking about attorneys and their conduct in our public courtrooms. These statements in these articles, they aren't statements about about Ms. Abrams' hair color or Ms. Abrams' personal life. They're statements about her conduct in court in a public courtroom. They absolutely fall under the protection of the anti-SLAPP statute, Your Honor. And because they do, and because we've met our burden that they do, the burden passes to the plaintiffs to establish that they have a prima facie case. And they can't do that, and they don't do that. In fact, in their omnibus opposition to the anti-SLAPP motion, Your Honor, they incorporate a lot of arguments from their 12b-5 motion. And while I do think they don't even meet that standard, they forget that on a special motion to dismiss, a plaintiff establishing a prima facie case is more akin to what the burden is on summary judgment. You have to come forward with actual evidence to support your claims. So just saying, for example, on information and belief, Sanson did this for a bad purpose, isn't enough. And by the way, Your Honor, even if Sanson were paid to make these statements, which he wasn't, that doesn't change the fact that it's protected speech. And all this silliness, this imagined conspiracy with Mr. Schneider, in the end, it's actually irrelevant. These statements on their face aren't defamatory. A reporter is paid to write a story. That doesn't make it unprotected speech, Your Honor. But Your Honor, they don't meet the standard. And I wanted to point out just one snippet from a case that I cite in the briefs. That's the Hilton v. Hallmark Cards, a Ninth Circuit case, and it says that if a plaintiff has stated a legal claim but no facts to support it, a defendant could prevail on an anti-SLAPP motion, even though he wouldn't have been able to win a motion to dismiss. And this just goes to the fact that under NRS 41.660 and also under California law, you've got to meet 665. You've got to meet a higher burden. You have to come forward with prima facie evidence and show a probability of prevailing on the claim. They just don't do that, Your Honor. defamation, I just walked through the main statements at issue, and these things, whether she was unethical, for example, they just aren't. They're matters of opinion, and they're just not actionable. The Nevada Supreme Court has said, for example, it may be actionable to state an opinion that a plaintiff is a thief if the statement is made in such a way to imply the existence of information which would prove plaintiff to be a thief. But the test for whether a statement constitutes fact or opinion is whether a reasonable person would be likely to understand the remark as an expression of the source's opinion or of a statement of existing fact. I'm quite sure that the paralegal at Ms. Abrams' law firm didn't believe Mr. Sanson, first of all, but second of all, understood that he was saying Ms. Abrams, in my view, violates laws, not that she's literally in jail or in prison. This isn't that kind of case. And you really have to look at the type of statement and whether or not it's susceptible to being proven true or false. He didn't say that Ms. Abrams has been found guilty of ethical charges by the Nevada Supreme Court and has been disbarred. That would certainly be susceptible to proof, Your Honor, but that's not what he said. He said he found her behavior to be unethical.
I'm not sure he said that. Where did
he
say that?
He said that the judge said that her behavior was unethical. And he questioned whether she should be reported to the state bar by the judge. But what the general elements of a defamation claim require the plaintiff to prove false and defamatory.
I'm not sure the judge said she was unethical either. So I don't think anyone said she was unethical. I think there were inferences.
There were different inferences, and the judge.
I mean, I guess she said if that's not an ethical problem, I don't know what is.
And
I don't think anyone ever said she was an unethical attorney.
Sorry, Your Honor, give me 1 second. I just want to pull up the transcript. So the judge says, ethical problems.
But Judge Elliott's not a party.
You're right.
So let's say even if she did say that.
Right.
I don't think she did. I think there were inferences, and she did say things about the firm filing things, but I don't think any of the parties here ever said she was an unethical lawyer.
Mr. Sanson raised concerns about whether her behavior was unethical, and if the judge had.
And his concern was, why didn't the judge do it?
Correct.
To me, it seemed like he was criticizing the judge more than the attorney.
I would agree with that, Your Honor. He said that a judge has a duty to control her courtroom, and that
Sure.
a judge has a duty to act and to report a violation to the state bar, which arguably is the other type of anti-SLAPP case, which is urging governmental action. The state bar is a quasi-governmental entity, and certainly saying to the judge, I think that if you said in court that you had questions about her ethical behavior, you should go to the state bar. That you should do so. That certainly was his opinion, and he's certainly entitled to ask her to act to enforce the ethical rules of the state bar. I don't know whether Your Honor wants me to get into each of the 11 causes of action, but the defamation claim, I think we've covered. These are not matters that are susceptible to proof. Even if they were statements of opinion by Mr. Sanson, they're not susceptible to proof, and he's clearly within his free speech rights to ask the question of whether or not Judge Elliott should have called the state bar to report Ms. Abrams. With regard to the intentional and the negligent and intentional infliction of emotional distress claims, Your Honor, first of all, this is not a 12b-5. This is anti-SLAPP. They're supposed to come forward with evidence. Ms. Abrams has not provided, she's alleged that she suffered distress in conclusorily element-style language, but she has never actually produced evidence that she suffered emotional distress. If she suffered emotional distress because somebody questioned her ethics in courtroom, this may not be the right career for her. But certainly a law firm is not a natural person and cannot pursue either of these claims. This is really a kitchen sink complaint, Your Honor. They just threw everything in they could think of. They didn't specify even whether or not the claims are being brought by both plaintiffs, but neither one of them has evidence. Neither Ms. Abrams nor her law firm have evidence of emotional distress. In terms of false light, it's an entirely inappropriate claim because it requires Nevada courts require that plaintiffs suffer mental distress resulting from publicizing private matters, Your Honor. Certainly, you can't have false light Jennifer Abrams wrote to Mr. Sanson and said early on, take down that video. It places me in a false light. First of all, the video speaks for itself. It's posted in its entirety, and it's not something private that's being disclosed to the public. All it is a video of her in court. In terms of business disparagement, the difference between business disparagement and a defamation claim is, for the purposes of this hearing, Your Honor, I'm assuming that Mr. Sanson isn't entitled to the federal court privilege, and I'm assuming that Ms. Abrams isn't a public figure. But so I'm just doing a straight defamation analysis as if those higher burdens don't apply. They can't even meet the lesser burdens because they haven't come forward with any evidence, and because the statements as a matter of law are not actionable. But the business disparagement claim, Your Honor, does require them to come forward with evidence of special damages. And they have not come forward with any actual evidence of damages to their business. I don't think that there were any. Maybe they've gotten some positive press out of this, who knows, or maybe they're suffering from the Barbra Streisand effect, I don't know. But they haven't come forward with any evidence of actual damages that their business has somehow been harmed. And again, this all hinges on a false and disparaging statement. So does the false light claim, so does the defamation claim, and we don't have any false statements. Harassment, it's not a claim in Nevada. We briefed this. The plaintiffs try to argue that you can bring any kind of common law claim you want. The Nevada Supreme Court hasn't explicitly addressed this question, but federal courts applying Nevada law have said that there is no state tort for harassment. There's only a crime for harassment, so there's no such claim. On concert of action, this is a claim that's predicated on another claim, so it's sort of derivative of there being an underlying defamation tort, which there isn't. Defendants are engaged in free speech, and these aren't antisocial or dangerous activities, which are generally the types of activities that the concert of action tort is meant to deter. You don't get a concert of action tort every time you have two defendants on a claim. And again, civil conspiracy requires that there be some underlying unlawful act or objective, and again, there isn't here.
Well, I think the civil conspiracy is the two, because the only way they get Mr. Schneider on any of these statements, because he didn't make any statements, is through this claim. Correct? That's what it appeared to me.
And they seem to, they put
Because no statements are attributed to Mr. Schneider. His only conduct is apparently getting a video from somebody, and their contention is he gave it to the other defendant and he uploaded it to the internet.
That's correct, Your Honor. I think they're suing previously all the defendants for civil conspiracy, but they also have this theory that Mr. Sanson and Mr. Schneider were sitting around concocting a scheme to go after Ms. Abrams, and that it was for some bad purpose, and that Mr. Sanson was paid to do it. But again, none of those things are true. But let's assume that they are true for the purposes of argument. That Mr. Schneider and Mr. Sanson met and said, you know, she's out of control in that courtroom. Something needs to be done for it. You know, I'll help you cover some of your expenses, Steve, but you got to do something to draw attention to this. That is not illegal behavior, because the underlying behavior, publicizing an attorney's behavior in a courtroom, is not possibly illegal. On the Rico cause of action, I don't really think they're serious about this cause of action. They haven't alleged with specificity exactly what this Rico cause of action is. Perhaps they can explain an argument, and I'll reserve my arguments for rebuttal. But the Nevada Supreme Court has made clear that you have to allege these claims, and this is not even on the anti-SLAPP motion, but just even on the 12b-5. You have to
allege them like you're charging them with a criminal indictment or information. It has to be that kind of specificity.
Exactly, Your Honor. On the copyright claim, this court, with all due respect to the court, has no jurisdiction. Federal courts have exclusive jurisdiction over copyright claims. And I think, Your Honor, the fact that they included all these claims goes to the idea that this is vexatious litigation designed just to bury Mr. Sanson, hope that he doesn't get an attorney, just bury him, maybe get a default judgment, and just bury him with paper. This court has no jurisdiction over a copyright claim. There's no reason to have included that claim. Their final claim is a claim for injunctive relief, which isn't actually a claim and isn't properly pled. You get injunctive relief if you win causes of action that give rise to the right for injunctive relief. But courts have made very clear, and we briefed this in our motion to dismiss, courts have made very clear, Your Honor, that when it comes to speech, injunctions are extremely inappropriate. Thank you, Your Honor.
Thank you. Mr. Potter, I'm assuming you want to be heard?
Thank you, Your Honor.
Do you agree that the allegations against your client arise out of the conspiracy?
Yes.
Because I couldn't see anywhere where it was alleged that Mr. Schneider made any statements. But he's liable apparently through a civil conspiracy theory?
Correct. I mean, the only, this all stems from the dispute between Brandon Leavitt and Mr. Schneider as to
Sure.
Mr. Schneider's client. His statement had already been made in the courtroom.
The email, I guess there was an email, and then apparently there was a conversation in court. Withdraw your motion, this all goes away.
And that dealt with the bar complaint that Mr. Schneider was dealing with Mr. Leavitt. Mr. Leavitt met with his client, Lewis's client, for 4 hours on the eve of the trial. He was still attorney of record at that point in time, and that was removed and was concerned that by that action, as to Mr. Schneider, our belief was that they were attempting, they being Miss Abrams and her entity, were concerned about that unethical conduct by Brandon Leavitt, and as a result of that, that's why it was included in this. In addition, there appears to be an evolving situation with Judge Elliott over there was sealed, the hearing was sealed, and whether it was closed, and clearly it's been determined.
But even if she closed the hearing, that doesn't mean it's not public record.
Correct.
Okay, that's my interpretation.
And that's
You can
our-
close a hearing, but the only way I can seal it is with a court order to seal it. I can close something, because sometimes you do that. If you're gonna have, I mean, you know, in criminal court, sometimes we close them because they're gonna talk about things that we don't want everyone to know about. So we close it, but we don't seal it. We don't take it from the public record.
And so in this instance, Ms. McLetchie has laid out the arguments with which we have joined in, as to Mr. Sanson being challenged for being a co-conspirator or a conspirator in Rico action. Totally, there's no.
What are the predicate crimes?
There aren't any alleged.
Okay.
So, based upon those factors, we would ask that he is under the ambit of the SLAPP suit, and we would ask for the appropriate dismissal and sanctions accordingly. We also had the 12B5 motion, but this supersedes that.
Sure.
argument. Thank you.
Thank you. So I want to start with Mr. Schneider.
Sure.
Is Mr. Schneider brought in to these statements based on the civil conspiracy? Okay.
That's exactly right. He spoke
Okay.
on the civil conspiracy claim, and the law is well settled on that. If you've got a conspiracy, all co-conspirators are jointly and severally liable for the acts of one another, even if they're not all known. So long as you've entered into this agreement to advance this objective, you're on the hook. So you are correct, Your Honor. The statements initially that we had when we complained about Mr. Schneider provide context, and I'm gonna get into that in a minute. But
Sure.
yes, to answer your question, he's hooked
Thank
on
you.
the conspiracy. So, Your Honor knows this, but I want to emphasize it this morning. Right now, we're on the anti-SLAPP motion, so
Sure
we're
we
not
are.
on the 12B5 motion.
Right, you have a heightened standard.
They do, and we do if we get that
Mhm.
far. And I'm going to submit to you today, we don't get that far. And we may have a productive conversation about some of this on the 12B5 motion. But we're not going to have a productive conversation about it on the anti-SLAPP motion, because it's their burden initially to come to court and to explain why they have been sued for engaging in statutorily protected speech. They have to do that. And if they don't do that, then we're done. And I sit down, and you rule on the motion, and we take up the 12B5.
I was not talking about what goes in a courtroom, public interest, so you might as well skip right to that.
Sure,
I mean, I
let's-
think it's subsection 3 of the statute.
With you on
I
my
think
paper.
that's what the parties argued. I know you argued that this was not a matter of public interest. How can it not be a matter of public interest? The public always has an interest on what goes on in the courtroom.
Well, let's look at the Shapiro factors, right? Because that's what tells us what public
Sure,
interest is.
the
So
5 factors.
We hear case law, and they cite tidbits of case law by why this could be public interest, this could be public interest. But you look at these factors, and you take them in context with what Mr. Sanson told Mr. Schoen. And it's almost indisputable that this is a private
Okay, so
dispute.
you contend that Mr. Sanson defamed the plaintiff. I mean, I don't understand how you can. So the conversation with the paralegal is another set of defamation?
Not defamation, Your Honor. That gives us context. You say, why am I
Okay,
talking
you're giving,
about-
that's giving
Let's
it context?
give this context. Why do
Okay.
I say that?
Got it.
He said to Mr. Schoen, she's on my hit list. She's on my
Well,
hit
come
list.
on, you called it a priority list. You can't call it a
Okay,
hit
fair
list
enough. Priority
in
list.
oral argument.
Why? Why is that, Your Honor? Because he decided, at Mr. Schneider's behest, to go online and to start defaming her, and to defame her through private email blasts. And I'll get to that in a moment, Your Honor mentioned that. VIPI, you step back a moment, you look at what their mission is. They're here to talk about political candidates, and they have a talk show that talks about political candidates. We vet who we like, we give out a list of people, here's who you should vote for, here's who you shouldn't vote for.
Sure.
Okay? Mr. Sanson did not say, I'm going to go vet all the family court judges, and I'm going to go watch proceedings in different courtrooms, and I'm going to see how different judges interact with counsel, with parties, and then I'm going to take a sampling of lawyers.
Does he have to do that before he makes these statements?
Well, what he does, if he doesn't do that, then he transforms a private controversy into a public dispute by focusing on just Miss
What's a
Abrams.
what's the private controversy? The
It is-
divorce action? It's not a
The
private
between
controversy.
Miss Sanson and Miss Abrams.
Okay.
So it's their,
Okay,
it's-
okay,
it's-
I see.
It's their private controversy. Mr. Sanson and Miss Abrams have a private dispute. But he's taken, and he says, I'm going to make that public. Let's look at the 5th Shapiro factor. A person cannot turn otherwise private information into a matter of public interest simply by communicating it to a large number of people. So Mr. Sanson says, hey, I've got a mic, and I've got a radio show, and I've got Facebook and YouTube and Google, and I can take my private dispute with Miss Abrams and publicize it and turn it into a matter of public interest. So I mentioned earlier he's not sampling the courts. And I said that because of what Your Honor is thinking. Hey, this is about a case, right? It's got to be a matter of public interest. He's going around talking about cases, what's occurring. No, that's not what he's doing.
And it was actually more critical of the judge than anyone. So how
both.
this turned out to be about Miss Abrams?
Well, because the hook is that she somehow can threaten Judge Elliott, and she can cause Judge Elliott to enter orders that really no other lawyer can do. And Your Honor sits there on the bench, I'm sure you'd say, no lawyer intimidates me. No lawyer can force me to sign an order. But that's the context here. That's what they're saying, is that she has this ability to scare Judge Elliott. Oh, God, yeah, I'll sign your order. We know that's not happening. We know that's not happening. Judge Elliott is very capable of deciding in each case, do I sign this order? Don't I sign this order? So to suggest that Miss Abrams...
Well, she signed an order saying no one in the world could put this
Well,
video on
let's-
the internet. I mean, she corrected herself,
and what
but
she did
I
is
think
she said
everyone
that
lost
looks like
sight
a-
of the First Amendment for a second.
She said that looks like a gag order, right? That's what she said. And so she went through the 3 factors. But we're
She
also
signed the
talking
order
about-
first, telling everybody to take it down. And Mr. Sanson did comply with those orders. I mean, he got an order that arguably he didn't have to follow, correct?
He initially says, I'm going to follow it, and then he writes
Right,
back and says,
but
I'm not going to follow it.
arguably he doesn't have to follow it, but he does. I mean, I even checked. It's not on YouTube, and there was something else that I'd never heard of before. What's the other website? What's the other website that he was alleged to have put it on?
Google Plus, Facebook,
No,
those
not
are the principal sites.
like a YouTube site. It's not on YouTube, and it's not on the other site. I can't remember because I'd never heard of the site before. But
Vimeo,
apparently,
I'm told.
Yes, that one. And it's not on there either. So he gets an order. He arguably doesn't have to comply with it. He never had an opportunity to be heard. He's got an order with a caption that doesn't have his name on it. He somehow gets brought into this, but he complied. Correct?
As I understand it, he posted it back.
Well, apparently it's on some
Russian website.
Right.
I understand it, so that you couldn't go and fix it.
right. I believe it is there. But I think both sides agree it is there. It's on some sort of Russian website now.
That's my understanding.
I mean, I'm assuming everybody in the world can have access to it that has access to the internet.
As my understanding as well, Your Honor. You see Judge Elliott's comments. She didn't want that video posted online. Why are we posting this video online? Why is Mr. Sanson doing that? Okay. At its core, this is a divorce proceeding involving 4 small children. And of course, what did Judge Elliott say? We got to focus on the best interest of the children, right? Priority number 1. Nobody's disputing.
Family court matters are public. Just because there's children involved doesn't make it private.
But there's a difference, right? Saying, I'm going to walk down to family court today, and I'm going to just go sit in the back, and I'm going to watch, and I want to see.
But you don't have to do that now. You can get everything on video, just like in this courtroom. You can go after today. You can even call my own clerk, and she'll give you a DVD of anything that happens in this courtroom. She won't even ask me. She'll just give it to you because it's a public courtroom.
Sure, and so people go searching for that, right? As you said, I've got to call the
They don't
court.
have to search.
I have
They
to
can just
call
get
down
it.
here and obtain a copy of that video and pay for it, right? I got to pay for that transcript. I can't
Maybe.
just go get it. That's my understanding. You're typically paying for the transcript because they're having to put it together.
It's not a transcript. It's just a
Or the
DVD.
video from the
You can get a video.
And
Think
so-
you might have to pay $20.
Okay, so that's $20, right? So it means that's a nominal sum perhaps to people here in the courtroom today, but maybe not to other people. Instead, what we have is I'm going to widely publicize that on Facebook, on Vimini, but I'm also going to send it through private email blasts. So let me.
Okay, because you argue, I have that in my notes. How do the emails, because it appears to me as though you argued that even if because the internet's a public forum, and you're not going to deny the internet's a
On
public
Facebook,
forum.
No, we didn't take
Okay,
that position. We said
all right,
that
but
email-
you did take the position that even if the internet is a public forum, that by sending it in an email, it was a republication that took it out of the public forum.
That's correct.
That it was like publicizing it for the first time.
That's correct, and the law is clear on this. Each act of republication is actionable. Now, the response here was, well, no, because if I'm speaking here today and I say something defamatory to 4 people, I've said
Well,
it
you're
once,
good because you're in the courtroom.
I'm good.
You
Let's
have
say-
immunity.
Well, let's say I was outside. Fair enough. Let's say
As
I was
long as you
outside.
don't start going crazy.
Fair enough. But even then, I think that we have to deal with
Probably.
deal with the litigation privilege. But let's say I'm standing outside and I have 4 people in front of me, and I publicize a defamatory statement. Of course, that's one act of publication. It doesn't matter if there's 2 or 100 people standing. But that's not what we have here. They are not contending that Mr. Sanson stood in front of 2 computers and said, I'm going to hit enter to make it go public on YouTube, and I'm going to hit enter to make it go through my email
That's
blast at the
exactly
same
what
time.
they alleged in their reply. Did you read their reply?
Counsel said that. Unless Mr. Sanson's going to
That's how I understood their reply.
That's argument of counsel.
that
We
the-
have to flesh that out.
I mean, it was in their reply. I read that last night. Because I was very concerned about your email argument, because the internet's a public forum, whether sending it to a private email, newsletter audience somehow took it out of the public forum. I thought that was an interesting argument.
And it's
Because
something-
in their reply, they alleged exactly what I just said, that he published it at the same time.
And I would find that quite interesting if he would get up here and testify that he did just that. I would find that quite interesting, because argument of counsel and response, that's fine. She can argue that, right? And if Your Honor wants limited discovery on that issue, I'm happy to take Mr. Sanson's deposition for a very limited purpose, and I'll say to him, hey, were you sitting at your multiple computers? And did you set it up?
I don't think you have to sit at multiple computers.
Well, somehow or another to be able to send everything out at the same time through different channels. I don't know, right, because I'm not him. But
Sure.
if you want us to vet that, Your Honor, I'm happy to do so. That doesn't seem practical, reasonable, or realistic. I imagine he first either puts it through the email blast, and then he goes and puts it up on Facebook, or the other way around. But those are successive acts. And if that's occurring, then the successive act, or the initial act, that's through the private email list that you have to subscribe to, right? That you have to be on. You have to be a member of. If that's the case, then we're not in a public place or a public forum. It takes us out of the anti-SLAPP statute.
Okay, so that's exactly what you're arguing?
Yes.
Okay.
Correct, Your Honor. Correct. Taking a look at the other public interest factors, Your Honor. The first one under Shapiro. A public interest does not equate with...
So how does this come out of the public interest? Because it's a courtroom case, it's happening in a public courtroom, and I know you argue it's not a public interest.
Correct.
Why is it not a public interest?
Look at the third Shapiro factor. The assertion of a broad and amorphous public interest is not sufficient. That's what we have. It's like, well, we're interested in courts. That's the very definition of a broad and amorphous public interest. We just want to know what's happening. It requires more than that. Otherwise, that factor wouldn't be here, right? And the Nevada Supreme Court wouldn't said, take a look at that. Because if we just have some broad, amorphous interest, that's not enough. And that goes...
Said you can't turn an otherwise private information to a matter of public interest by communicating to a large number of people.
So they failed there. They fail under the third factor, which is there must be some degree of closeness between the challenge statements and the asserted public interest. The assertion of a broad and amorphous public interest is not sufficient. They fail there too. They fail there. And that becomes even clearer when you look at this...
Even though these courtrooms are run by elected judges, I mean, there's nothing more... I mean, the courtroom is a public forum that the public has the right... I mean, I can't deny anyone access to the courtroom unless I have a valid reason.
I understand the struggle. You say, we're
Sure.
talking about courts, right? But it's
They're
gotta be more
public.
than
They're
that.
open.
And they are. I can't deny that, right? I'm not going to sit here and deny the obvious. But it requires...
But you're taking
more.
something that happened in a public courtroom and you're saying it's not a public interest. Even though it's run by a public official who's elected by the people.
Sure. I'm looking at the facts, right? You have to look at the facts that are presented to you here today. Again, this was not an individual who was vetting courtrooms downtown in family court. He went out of his way to target one lawyer.
Okay.
Shapiro says, then we're not a public interest, okay? And why is that significant? It doesn't mean necessarily that we're going to trial on these claims now. It doesn't mean that. It means they don't get the benefit of the anti-SLAPP statute. They may get relief under 12b-5. I don't think they do. I don't think we get there. But they don't get anti-SLAPP relief. Why? The Nevada legislature has said, look, defamation, statements of opinion, some of that's a close call, some of it's not. It always depends. That's the judge. You decide, does this go forward, and a jury looks at these statements. So they can come in here on a 12b-5 motion. And they don't have to worry about truth. They don't have to worry about that. But the Nevada legislature has said, if you're going to come in here on a defamation claim, on an anti-SLAPP motion, we're going to make it a little harder. Why are we going to do that? Because you're wanting fees, and you want damages. So if that's what's occurring, and you are not
Well, the
only
fees are
asking-
mandatory, are they not?
Correct. If you grant the special motion, fees are mandatory, right? So then that can't be easy, because otherwise we're going to convert every 12b-5 motion on a defamation claim to an anti-SLAPP motion. And if
This is
the
only the
Nevada
second one I've had in over 15 years, so I don't think that's what happens.
Well, and
I mean,
don't think that's supposed
anti-SLAPP
to
law,
happen.
anti-SLAPP motions are not like run-of-the-mill.
It's not supposed to happen.
Correct.
You're supposed to be in here on the 12b-5, but they're in here asking you for the benefit of the anti-SLAPP statute. But let me do this, Your Honor. Let me move to, even if you're struggling with public interest, and I understand that. And then we have the public forum issue.
Sure.
Which I think they have a real problem with. They have a real problem with. Because a lot of this, again, all of it republished through a private email. But the third factor, Your Honor, and one that we hear today that actually they really don't have to comply with, is truth. They can't disagree with that. The statute says it's got to be truthful or made without knowledge of its falsehood. We're done. They don't even bother to do that. Instead, what do they say to you? Well, no. These are statements of opinion, so I don't have to prove truth. The Nevada legislature disagrees, and so does the Nevada Supreme Court. In Shapiro, it said, oh, and by the way, any communication that you're trying to squeeze into the anti-SLAPP statute it better have been truthful or made without knowledge of its falsehood. They don't.
How about putting a video? I mean, because everything stems from this video. That video is truthful. That's what happened.
The video.
So you can't deny that. I mean, it speaks for itself. It may, I mean, I sat and watched the whole thing. It took a really long time to sit through the whole thing. I know what happened at the end, but the beginning of that all happened. I mean, it wasn't nice, you know, but it all happened. It's truthful. That happened.
But that's
So
not what
putting
this
that
article
on the
does.
internet doesn't somehow turn it into defamation. But everything stems from that video, correct? All the statements, everything
I
stems
think that's the
from that
genesis.
video.
I think that's where we start.
And the truth is an absolute defense. It's not defamation if it's truthful.
But this is not just, hey, everybody ought to go watch this video. That's not what this is. This wasn't just, hey, I thought this was really interesting, and I'm here to make sure everybody knows what's going on. Go watch this video. That's not what happened here. We decided to only talk about, Mr. Sanson said, I'm only going to talk about the first part of the video. And everybody knows, everybody reads headlines, right? How long did it take? I mean, it's a 78-minute video.
Oh, I thought it was like 2 hours, but
It
apparently
feels a
it's
lot
not.
longer when you
Felt
watch
like
the
2
video.
hours, but it's
Right.
only, when I saw it was only 70 minutes, I thought, I would have sworn it was like 2 hours. It was long.
Yeah, and I think, they've done studies now that the average person's going to read an article for maybe up to 30 seconds if it really grabs their attention, right? The idea that anybody is going to sit there, click that video, sit back, get a drink, and watch that video is ridiculous. And even Judge Elliott said in her email to him, it's really not fair how you've portrayed that video. Of course, she took offense to it too, as you alluded to earlier. It's got to be a fair accounting. That's not what they did here. Because they know nobody's going to go watch that video. Headlines are what matter. That's what sells in the news. Headlines. And this headline here, when read in context, if we're jumping ahead, is defamatory. But I want to back up. Because truth, again, they have to prove truth. And they can't do that with how they portrayed the video. I didn't put those words in that article. They did. They did that. And Mr. Sanson does not say in his declaration, Mr. Sanson did not say in the article, oh, hey, full disclosure here. The judge was misinformed about the plaintiff's finances. Full disclosure, you don't see like a footnote, a little disclaimer at the end. Well, he doesn't want to do that. That's not his objective. So truth. That's why they fail under the truth analysis there. Some of the other things, Your Honor, they talk about the articles with bullying, threatening. Again, do they say, look, here's how I would prove that? Here's at least what I would do if I had to prove that. No. We have argument of counsel that talks about why those are statements of opinion. That's fine. And again, if we want to have that discussion under the 12b-5, let's have it. And I think that'll be a productive, meaningful conversation. But not under the anti-SLAPP statute. Because they had to prove truth. Good faith. Those are the words that our Nevada legislature used. Those words were reaffirmed by the Nevada Supreme Court in Shapiro.
And what if it's an opinion? I mean, an opinion can never be false, correct?
People all the time are testifying, here's my thought, here's what I based that on. Here's the facts that support my opinion, right?
Uh-huh.
We don't see that.
But an opinion cannot be false. So if it's an opinion, it's truthful.
Well, we can argue about whether these are opinions. I don't think they're
Okay.
opinions. But
All right.
the problem here is they just assume they're opinions, and they don't say, you know what?
They
I'm gonna
assert,
be
they don't assume,
fair.
they
argue.
assert that they are opinions. So I'm wanting to know from you, why are they not opinions?
Okay.
Because if they're opinions, they can't be false,
So
right?
what-
Because I understand they have to prove truth or no knowledge that they were false. I'm just kind of wondering how you can prove truth or false if someone's a bully.
You would still
Do you
have
know what I
predicate.
mean?
I
Like
do.
bully.
I
mean,
understand.
isn't that someone's opinion?
Well, what they've also done, Your Honor, is they're cherry picking and they're trying to cut these articles up, right? That's not what you do. You got to read them in context. And the Nevada Supreme Court has said, what would a reasonable person think when they look at these articles? What would a lay person think? And as I alluded to earlier, they would think that Ms. Abrams is able to threaten a judge. You better sign this order, or things are going to go very south for you.
Where does it say she threatened a judge?
The bullying article, that she's bullying. Judge
Why are you
Elliott.
saying they said she threatened a judge?
I'm saying that's how I would maintain, Your Honor, that
Okay.
that article would be interpreted by a layperson. The Nevada Supreme Court has said to you, Judge.
And
when
they
you're
actually
looking at
posted the order. He was served with an order, and isn't this actually the order? Looks to me like the actual order.
on the,
Right.
you're looking at Exhibit 3, Your Honor?
I mean, he actually posted the order for everyone to see, so they could form their own conclusions, right? It's Exhibit 2.
Correct, Your Honor. He's got the order posted. He does have the order posted. But what does that tell the reader? He must know a lot about this case if he's posting pleadings. So there must be something else that happened. He bullied her and he caused her to enter that order. Okay? The Nevada Supreme Court has said, what would a reasonable person think when they look at this? And if it's subject to more than one interpretation, then what do? We bring a jury in. Now they might say, come on, I think that's opinion, as opposed to fact. But that's a jury question. If it's a mixed type
So
statement,
an opinion is always a jury question?
whether, if the Nevada Supreme Court has said it's a mixed type statement, which means there's some undisclosed defamatory facts, if a reasonable person,
So the defamatory statement is bully?
when read in this
Bully?
article, Your Honor, again, I don't think we can chop this article up, which is what they want to do. You got to look at the entire article. What's the message being conveyed? Okay? Now, you made a comment about unethical earlier, right? Where is it that they call her out point blank that she's unethical, right? You read the article, isn't this unethical? Anybody who reads that's going to say, well, he's calling her unethical. Again, you have to look at the article.
I read it, and I said exactly the opposite. So,
I'd
I'm
say, Your
somebody.
Honor, you are, and you're the one that's most important looking at this statement, Your Honor. If there's an ethical problem or the law has been broken by an attorney.
and that, he was critical of the judge. That's true. If there's an ethical problem taking place in your courtroom, you do have a duty to report it to the appropriate governing body. We may not like that, but that's the truth.
But ethical problem with who?
With the attorneys.
Exactly.
But
She's
that's
done
true.
something unethical. She's done something unethical. That's what I read from this article, Your Honor. That's what I would submit that a layperson reading this would say.
Well, the judge didn't report her, so clearly the judge didn't think it.
Correct.
And that's the only person that matters,
Did
right?
he say that in this article?
He said that a
The
judge
judge
is
didn't report
supposed to, he says a judge is supposed to report somebody. So if the judge didn't do it, the judge is the one being criticized. There's nowhere in here does it say Miss Abrams is unethical.
Point blank, you're right. That's correct.
Right.
I would submit that you read that article in context. That's the only logical conclusion to draw from it. But let's move from that one then, because there's other ones too. This stuff about sealing, that she's sealing stuff, and it's unsupported in law. I mean, do we have any citation saying here's why you couldn't seal certain elements of these cases? No. And again, that goes back to this idea that she can get judges to just blindly sign orders. She can't do that.
Again, I emphasize the criticism is on the court and not necessarily the lawyer. Because the lawyer is not sealing cases.
Correct.
The court is.
But what they're saying is, how dare she go in there and ask the judge to sign an order that she knows the law would not allow her to do?
And that's a problem with the judge, isn't it?
It could be as well. But do they come in here and, as part of proving truth, say, here's why that was a problem for the judge? Because look at NRS such and such. You couldn't seal that. They don't do that. They don't try to do that. Because they can't do that. So why is that significant? I'm going to bring it back again. Anti-SLAPP. If you want anti-SLAPP relief, which is better than 12b-5 relief, right? So they're not in here under...
Well, they did list the docket of all the cases that apparently have been sealed.
So you look at that, and what they're saying is she shouldn't have sealed any one of those cases, right? That's the position.
Where does it say that the court should not have sealed those?
Calling her seal happy, and it's unsupported in law.
Okay.
That is the, I believe it's the November 6 article, Your Honor. And my point is this: if they're going to say you shouldn't have sealed that case, then they'd have to do something.
They have to say that first.
But to start calling her seal happy, again, the only implication to draw from that is that she shouldn't be sealing those cases.
I think the only inference is that she has petitioned the court maybe several times and the court has granted her petition. I mean, no one thinks an attorney can actually seal records, right?
I don't think so.
And I don't think there's any,
So page 4 of this article, Your Honor.
okay,
It's the last paragraph here. Talking about such blanket prohibition on public access to the entire case is specifically disallowed by law. So they're gonna post that what she's doing is specifically disallowed by law. I would submit that some element of truth has to be behind that to get past the first step of the anti-SLAPP analysis. And if we don't get there, if we don't have that, then we're done. And we sit down and we have a debate about the 12b-5 motion. But I think I've belabored that point, Your Honor. So I'll move to.
well, and isn't it true? Because didn't Judge Elliott correct that?
She did not say I'm going to unseal the case. She said her order saying nobody can disseminate that video everywhere. That I have a problem with, she said. So that was the gag order portion that I
Okay,
mentioned earlier.
but she didn't seal the underlying divorce case, did she?
As I understand it, the records from that case, which is allowed under NRS 125, were sealed.
She did,
Yes. So
she
that's-
did eventually
there's a
seal the
difference.
entire,
There's
when
an
did she
order-
do that?
3 days later.
When?
She sealed the case, I believe it was October, or the beginning of November. It was
Okay,
months
so
prior.
after,
It's 3
It was
days.
months prior to the order, the gag order.
So we have
okay,
two things,
but
right?
after the publication?
No.
Okay, somebody tell me when she sealed this entire divorce
Let me-
case.
Yeah, let me find it.
Okay,
So it was a closed hearing, and then she sealed the case a few days later.
okay. Is it still sealed?
Yes, it is.
Okay.
Date, Your Honor, so that we're all on the same page.
So again, if he's contending that should have been disallowed, he's criticizing the judge, not the lawyer.
But
The
if-
lawyer just petitions. The lawyer's supposed to zealously advocate for their client. If they have that's what they're supposed to do. And then
They
you
are,
let
but
the
lawyers-
chips fall where they may, and the court signs an order or doesn't sign an order.
But lawyers don't go in there and say, Judge, I want to have you do something, and I know as I sit here in my head that it's specifically disallowed.
Of course
by law,
not,
right?
yeah.
Exactly. But that's what's drawn from this. They take it a step further. She's asking the judge to do things that she knows she shouldn't ask that judge to do. That's the rub. That's the problem. What you get from these articles. It's not just Judge Elliott. It's Miss Abrams. She's going in there asking for things that she has no business asking for as a lawyer. That is the reasonable implication drawn from these articles. And if we have that, Your Honor, which we do, then they fall outside of a pure statement of opinion. It becomes a mixed type statement that a jury has to look at. And again, I said this, the jury might look and say, you're reaching. But as a matter of law, they come to you today and they say, under no set of circumstances could anybody read these articles that way. That's what they have to have you find. Nobody could read any of this and find that these are pure statements of opinion as a matter of law. I think that is too far of a reach at this juncture. Again, we might do some discovery, flesh out a little bit what's going on here, and they may come back in here under 56 and say, Your Honor, there's no way a jury could ever read this way, because look what we did. We went and got an expert who looked at these opinions, polled, did a sampling, right? I took this article to 100 people. They can come in here to you with evidence like that and say, let's not waste time at a trial, because now I don't think there's a question of fact. I think that'd be hard to do, but we're here right now under anti-SLAPP and 12b-5, and they're asking you to say, as a matter of law, this statement shouldn't go to the jury. This statement does not create a mixed type statement. I don't think you can find that at this stage, Your Honor. I feel like I've gone back and forth over the anti-SLAPP first step, second step. Your Honor, let's say it gets past the first step. It says, you know what, I think it's public interest.
The burden shifts to you, then what?
Then the burden shifts to me, right? First of all, this idea that we have no evidence presented, that's false. First of all, you look at our opposition. We've got all the articles attached, right?
Okay.
Ms. Abrams initially verified the complaint, but then she also did a declaration attached to the opposition. There's no case saying you can't
Okay.
verify a complaint.
What are your predicate claims on the RICO action?
The RICO, I don't think you get there on anti-SLAPP because it's not dealing with a communication anymore, right? You look at the crimes that are alleged; those are not communications by definition.
What are the crimes?
I would submit, Your Honor, we need to do more on the RICO claim. I
So
can't argue
you
that.
know your RICO claim fails.
I think we have to do more. I think it
Okay,
fails
well,
under
I
12.
appreciate that.
Under 12b5 though, as opposed to the anti-SLAPP, because if the conduct.
Well, I get concerned when you're filing RICO actions and alleging people committed crimes.
No, I
I mean,
understand
if you're going to do that, then do it right.
I understand that, Your Honor. I do.
Okay.
Do.
So you admit today your RICO claim
I think under
has
12b5,
fails.
the RICO
Okay.
needs to be dismissed, and we'll take a hard look at whether we want to amend to add that back or not. My recommendation would probably be to not add it back,
Okay.
right? But
I appreciate that.
That's under 12b5.
How about your copyright claims?
Same thing under 12b5,
Okay.
but not under NRS 41660.
And you agree injunctive relief is a remedy?
It is a remedy, Your Honor.
Okay.
Look, the idea is here is to make it clear to Mr. Sanson what the relief is.
Do you think harassment is a claim in Nevada?
You look at the District of Nevada cases, Your Honor, we can't argue with that. The
Okay.
point here is, look,
So you agree harassment goes to?
under 12b5.
Okay.
Under 12b5, Your Honor, not under NRS 41660.
I appreciate that.
What we have, Your Honor, is, look.
So really you think, how about your intentional infliction of emotional distress?
I think whether this is extreme or outrageous, are we
Can be
deciding
determined,
that as a
well,
matter of
it
law?
gets determined as a matter of law, and you have to show damages, and the damages can't be just, I'm stressed out. I mean, the case law is very clear on that.
Oh, sure.
So if the burden shifts to you, that's what I'm asking you.
And we have the declaration from Ms. Abrams where she addresses that, and she puts more meat on those bones, so to speak.
Okay?
Under NRCP
So
8.
I'm stressed out, and I'm not trying to, because no one likes this, and I'm not trying to minimize it, whether it's right or wrong. No one likes this, so I'm not trying to minimize, how she feels. But you understand it has to be extreme and outrageous, and there are certain things that we're required to take in a society. And are you contending these statements are of that level, extreme and outrageous, and that she has suffered severe damages?
I think in conjunction with how we got here, it becomes that way. In
Okay.
conjunction with Mr. Schneider making it clear at the outset, I'm going to do more than just oppose your motion. And I don't think there's any dispute he gave.
I'm sorry, what?
That's the initial email from Mr. Schneider to Ms. Abrams, or actually Mr. Leavitt,
Okay.
saying if you don't withdraw that motion, I'm going to do more. So that's where we started. And then the conversation with Mr. Schoen in December, where priority list, right? When you look at context, this is somebody going out of their way to do this. That's what I would submit makes this extreme and outrageous, Your Honor, as opposed to just somebody who walked into court one day, caught her arguing in that case, and then decided to go on and write about it. Then I don't think we would get there.
Okay.
But that's not these facts. I think these facts get you there. But I can
Okay,
understand if
but
you're struggling,
again,
Your Honor,
to
with
get Mr. Schneider here, I have to make that leap that he gave it to Mr. Sanson for a bad purpose.
You don't need a bad purpose. No.
Okay.
Conspiracy is two or more people who come to.
You have to have an underlying unlawful objective. You have to have an agreement to commit a tort,
Correct.
right?
To commit a tort. Correct. I know the mention was illegal. Doesn't have to
Okay.
be illegal, right?
Well,
You
it
have to
has
have
to
two
be
people
bad. There has to be some sort of bad element.
You have two people who come
Okay.
together.
So again, I have to agree that they entered into this agreement, I guess, to defame them.
Yeah, and remember, on this motion, if we're either under the anti-SLAPP or we're under 12b5, either way, the inferences are drawn in our favor. No, I don't have the
Well, under
conversation.
the anti-SLAPP, you have to come forward with evidence.
I did. So what did we come forward with?
The burden is a
We
little
have-
bit higher.
So let's look at the evidence that we have, right? The day after the hearing, Mr. Schneider requests a copy of the video, right? Nobody's disputing that. And then a few days later, it
Well,
shows up
I mean,
on
I
the
guess
internet.
if there's no other evidence that the video was distributed, I'm assuming the person that gave it to Mr. Schneider is the same person that would, well, I don't know. Maybe there's a lot of people that could give that video here. I don't know. I don't know if only one person can give the video to somebody, or if you could call court administration. I don't know. But the only evidence here is that Mr. Schneider was the only one who got the video, right? So if Mr. Schneider was the only one who got the video, he had to have given it to Sanson?
Well, correct, Your Honor.
Okay.
And how easy would it have been for one of them to put in a declaration, I didn't get the video, or I didn't give the video? You don't see that. Mr. Schneider's here today. You can ask him, did you give the video to Mr. Sanson? But it's not just that.
Well,
Your Honor.
and
We also have emails.
okay, he did.
Okay.
Let's say he did.
So then why is
So
he giving
what?
him that video? That's the agreement, Your Honor. The
Okay.
agreement to go after and target Miss
But if
Abrams.
you post, I'm trying to figure out how you get Mr. Schneider here. Because if Mr. Schneider gives in the video, it's of a public proceeding in a public courtroom. It's true. Correct? And the video got played in its entirety. What did Mr. Schneider do?
He, as far as what we know and what we've
He gave the
heard so far,
video.
Your Honor, he gave the
Let's
video.
say I agree. He gave the video. So what?
And then he said later, also undisputed, I can make all this go away. What does that mean?
I don't know. I don't know
Neither
what
do
that
I.
means.
But let's, the reasonable inference to draw from that, Your Honor, is he's behind this. He's behind
Well,
this.
I mean, now I don't think that anybody tells Mr. Sanson what to do, but I don't know.
I don't know. I don't know. I'd have to take depositions. But to go back to your point, Your Honor, yes, I've got to hook Mr. Schneider on the conspiracy claim. Without that, he's not hooked here because, no, he did not post, as far as I know.
Okay, but what is the evidence that they entered into this conspiracy to commit defamation? Because just giving the video isn't bad. It's a public document.
The evidence,
Correct?
I think the evidence would be that he gives the video, makes it clear to my client that he could stop this if she withdrew the motion.
Okay.
And then from there, we have to go into the substance of the actual acts themselves, right? And whether or not the acts themselves you find are defamatory or not.
Okay. I appreciate you answering all my questions.
Sure.
I mean, the briefs were very, very good. I know they were long,
They were long, and
and
we
you
filed
filed it in
motions to try-
excess of the page, but I'm okay with you
we
filing
filed
it in
a motion
excess
for
of the
leave to
page
have
limit.
to grant that request
You did,
because,
and I saw that.
I don't want to give you 3 briefs if I can give you 1.
No, and I
Right.
I figured that you didn't want to oppose all 3, and I think they were both sides. The issues were very well briefed, and I do appreciate that, and I appreciate you answering my questions.
Okay, a couple other points, Your Honor, and then
Sure.
I think I'm done. It doesn't sound anymore like they're going to argue that she is a limited purpose public figure.
I don't think she is,
Okay.
if that
It doesn't
helps.
sound like we're going
I
through
don't
that.
believe she's a public figure.
Okay, so then I don't have to go through that. And then there was a little bit of discussion in the briefs about the fair reporting privilege, but we know that's got to be an accurate and complete accounting. I didn't hear much about the fair report privilege today, so I don't, unless Your Honor has questions about that,
Sure.
I don't think we need to go into that. So, Your Honor, in conclusion, I would say that they don't get past the first hump of the anti-SLAPP analysis. And California cases are very clear. We won't look at the merits of the claims. We may do that here in a minute on the 12b-5 motion. But for purposes of anti-SLAPP, they don't get over the hump. But if they do, what does the California cases say? You gotta have minimal merit. It's not the summary judgment standard anymore. Our Nevada legislature changed that. These claims have minimal merit at this stage of the proceeding, Your Honor. Lastly, if you think there's reason to flesh some of this out, we did make a request for limited discovery. Again, it's not full-fledged discovery, but if you think there's just a couple of things you'd like me to flesh out, I'm happy to do that. We can come back in here in 90 days, 120 days,
Okay.
and resolve those few remaining issues.
Right.
Thank
Thank
you, Your
you.
Honor.
I do believe I have to resolve this motion before we can go on to any 12b-5 though. And procedurally, you agree with that?
That's up to Your Honor's discretion, but I would say that if you require limited discovery, yes, you wouldn't rule on the 12b-5. Everything would get continued.
Right.
So if you say, you know what, I'm going to let you do discovery on these things that I have questions about, then yeah, we're going to continue out the 12b-5 motions. We'll continue out the 12f motion. We'll come back, get a decision after additional evidence is submitted on the anti-SLAPP, and then decide whether you're taking up all or portions of the 12b-5 or 12f motion.
Okay. Thank you.
Thank you, Your Honor.
Anything in
Can
response?
I just correct a few
Sure.
things that were stated?
No problem.
Your Honor indicated that Mr. Sanson did follow the order that was issued by Jennifer Elliott that he was served with.
It-
He actually did not follow that order
Right.
at all.
Excuse me, I'm going to object. Is she testifying as a witness? Is she here as a
Correcting the
counsel?
record with regards-
Okay, well, let me just tell you, everything's gone so well so far. Why don't you tell your lawyer and I'll hear from your lawyer, okay?
I'm counsel, and normally I would say these things.
I thought that you were, okay, I know that you filed the complaint, but it appeared to me as though Mr. Kennedy came in your stead. Is that not true?
He didn't substitute. I believe he associated, and I'm sorry.
That's okay.
The reason she's talking is that I can't speak very well.
Okay, well, I'll let her speak to her attorney, and then,
So,
because I know everybody's attorneys, and if I let everybody talk, we'll never get out of here.
I apologize for the voice.
And plus, I got a bunch of attorneys in the gallery that are smiling too. They don't want me to let everybody talk.
We know some of them.
So, Your Honor, the
Sure.
follow the order. I will go full the actual declaration for you, but as we understand it, he continued to republish it after he initially got the. But let me
Okay,
grab that.
but not, my statement was, it appeared to me as though he complied with it and took it down off YouTube, took it down off that other thing that posts videos. I know because I tried to find it. I couldn't find it.
Well, what happened?
Okay,
Your
I
Honor,
went
is-
on YouTube and YouTube said, this video has been removed. I went on the other site, it said, this video has been removed. And to tell you the truth, I watched the whole video, but I think one of the parties attached it for me because I was able to watch it on my computer in its entirety.
I know requests were sent to YouTube to remove the video, and I believe it was done.
I guess it wouldn't be him that took it down, it would be YouTube that took it down. And you know, that's correct. If my memory serves me correct, I think Miss Abrams' firm
Sent the
sent
notices.
something to those
Correct.
particular. You're right.
Correct. So I
She
think that
sent
was-
notices and then they were taken down.
Correct.
But I know they're not there.
They're not there anymore. Thankfully, YouTube said you're right. We got to take that down.
Right. Well, I don't know what YouTube said, but they took it down. Okay, anything in response?
Yes, Your Honor, I'll try to be brief. Your Honor, speaking of the operation of government, including the judicial branch, is in what they call the upper echelons of what the First Amendment protects. In addition, the other key point I want to make is there's no such thing as a false idea. They would have you believe that Mr.
I guess
Sanson-
they're contending those weren't opinions, that it's like a mixed question.
Right, and they would have you believe that somehow Mr. Sanson needs to testify or submit a declaration saying that
This
each
is true.
opinion was a fact. The things that are factual are undisputed. It's not disputed that Ms. Abrams got an order requiring that he take the video down, and that order was later rescinded, for example. And certainly, and Mr. Sanson discusses this. And certainly, Your Honor, it's someone can express an opinion based on those things. There is no need. This over-technical read of the statute was expressly rejected by the California court in Piping Rock Partners, which is quoted in the very recent Nevada Supreme Court, February 2017, Shapiro v. Welt case. And in that case, they said, we're not going to require that kind of separate proof of validity for literally each statement. They rejected exactly the kind of approach that the plaintiffs are urging in this case. And when you look at the statute, what it requires is essentially a good faith communication. It says, which is truthful or is made without knowledge of its falsehood. Mr. Sanson's declaration in detail explains the statements and the context in which they were made. They explain that the IPI speaks out against what it perceives as public corruption and wrongdoing, and it explains that, in his opinion, she seals too many documents. He is entitled to that opinion. It's not disputed that she seals documents. She sealed the video in this case. So the idea that he needs to go through in order to get the protections of the anti-SLAPP statute and break down everything and assert that things that can't be proven true or false are true is just, I think, with all due respect to opposing counsel, is just absurd. With regard to the Shapiro factors, I think it's a real contortion to say that the Shapiro factors don't urge in favor of finding under the anti-SLAPP statute. And Your Honor is correct. You do have to deal with the anti-SLAPP statute, the anti-SLAPP motion to dismiss first, and it's for an important reason. In 2013, when the Nevada legislature amended the statute, they made clear that you are immune from a civil action, not just liability. And they're not entitled to discovery, Your Honor, because discovery wouldn't help us in this case. This case is essentially about the statements. No one's disputing that the statements were made. At one time, they had sued everybody Steve Sanson knew, I think, actually, pretty much, that they thought he was close to, listed everybody they thought was involved with VIPI. It's not VIPI, by the way. It's VIPI, or Veterans in Politics.
Okay.
But they sued everybody and threw in their kitchen, threw everything into the complaint. Now it's just Sanson and VIPI and Mr. Schneider, and it's clear that Mr. Sanson made these statements. We don't need discovery on any issue, and I think that allowing discovery would run afoul of the anti-SLAPP protections, because it's clear on the face of the complaint that it's an invalid complaint that Ms. Abrams brought in order to chill Mr. Sanson's speech. This isn't a private dispute between Ms. Abrams and Mr. Sanson. They didn't know each other. They're not friends that had a falling out. This is a dispute about whether or not she seals too many documents, about whether her conduct in court is appropriate. And those are certainly matters, as this court has indicated, of public interest. The California court, which I think the parties all agree, Nevada looks to California. The California court has made very clear that public interest is to be interpreted broadly within the spirit of the anti-SLAPP statutes. And it's anything that the public is interested in. Mr. Sanson's members, Mr. Sanson's readership, Mr. Sanson, the people who look at his Facebook page and access other information like the YouTube and Vimeo or whatever it is.
Yeah, I did.
They're interested in these issues, and they can and should be. They are entitled to look into issues about the administration of justice. As one court has explained, we could all end up in court one day, and certainly family court especially. And people have a right to know what goes on there, how lawyers act there, and how judges act there. With regard to this idea that somehow, because he has an email blast that's sent to thousands of people where he republished the information, that somehow this takes it out of a public forum. I really think that ignores the context of these emails. It's not a private email from Steve Sanson to a friend of his. It's a list of thousands of people, and I think I explained earlier, this is a lot like if the Review Journal had a service where they sent alerts with their articles to its members, to its subscribers, right? That it's no different. And frankly, an email subscription to a list is almost, in this modern world, a lot of people don't get hard copy versions of anything, and certainly Mr. Sanson operates almost entirely in the virtual world. He knows more about video places than you or I do, Your Honor. But in these days, instead of subscribing, for example, to a newspaper, a lot of people sign up for email alerts from the New York Times or Politico or other publications, and people that are interested in the issues that Mr. Sanson reports on. And he is a blogger, and I do think that he's entitled to protection under the fair report privilege. There's no need that he literally needs to transcribe the entire video, but I don't think we even need to get to the fair report privilege, because I don't think we have we don't have a defamatory statement. They do have the burden of establishing that the statements are unprivileged, but I don't even think we need to get there, Your Honor. But I do think he's entitled to it. There's no need to have, I think Mr. Gilmore said that you need to have footnotes and you need to explain everything that happened. That's not true. The focus of Mr. Sanson's article was on the interchange between the judge and Ms. Abrams, and that was the focus. That later on, it's true, the judge did rescind her position or retract her position with regard to Ms. Abrams' client. That's not the point of the article. A newspaper doesn't need to, for example, report on exactly everything and literally every word that's spoken in a courtroom proceeding. The focus of the speaker's conduct should be the public interest rather than a mere effort to gather ammunition for another round of private controversy. Again, there is no private controversy here. don't even know that Mr. Schneider and Ms. Abrams have a personal relationship. This is a controversy, not even just about a court proceeding and a court case, but about how courtrooms should be run and how lawyers and judges should act in court. And in terms of the degree of closeness between the challenge statements and the asserted public interest, as I pointed out earlier, he writes these articles about what the Nevada Supreme Court has said about sealing, and then he says, hey, you know, in my opinion, she seals too much. And with the idea that Mr. Gilmore put forth that somehow he needs to prove that she seals too much, that if you could prove that a document had to be sealed or didn't have to be sealed, if the world was black and white, we wouldn't need lawyers. People all the time argue this document merits sealing or this document doesn't merit sealing. And Mr. Sanson is certainly entitled to express his opinion on these issues as well. Your Honor, Mr. Gilmore conceded that they don't have valid claims, I think, for Rico, copyright, and injunctive relief, and then went on to say, well, they really have nothing to do with his speech, so they should be dismissed on a 12b-5. That's incorrect, Your Honor. I think that the fact that they didn't allege valid claims shows that this was a scorched earth part of a scorched earth campaign that included trying to haul Mr. Sanson into family court and throw him in jail. This was part of a scorched earth campaign. These causes of action were included because they didn't.
Did they really ask for jail time?
Yes, they did.
Because I reviewed that order. Okay.
They did in their order to show cause, Your Honor. It was obviously denied. And thankfully Mr. Sanson is here with me today. But Your Honor, these claims, the fact that they don't have any validity shows that this was a kitchen sink operation designed to just try to bury what they probably hoped would be a pro se defendant in paper. I think it is directly connected to the speech. The copyright claim, for example, has to do with the video. And the Rico claim, just because they can't articulate a valid claim, isn't a reason that we shouldn't grant relief under the anti-SLAPP statute. This idea that this case is a 12B5.
You believe you should be granted relief under the anti-SLAPP and not 12B5?
Absolutely, Your Honor, because they don't have valid claims. I think it's a concession. I think it reflects, it's not a concession on their part, but it certainly reflects, Your Honor, that they're pursuing this action in order to get him to take down the video, in order to get him to stop talking about Ms. Abrams' behavior in court. It is their position.
Well, that is what they're trying to do. They have a claim for injunctive relief. I don't think that's a secret.
Right. And so all of those claims are directly tied to his speech, which again is protected opinion for all the reasons I went through earlier. And again, the idea that because he has an email blast that goes to thousands of people, that's not a public forum, I don't think is a valid position. And even if it were, Your Honor, then it would just take those publications outside of the reach of the anti-SLAPP statute. You can still grant partial relief under an anti-SLAPP statute, and obviously those claims would still have to be dismissed under 12b-5 because for the very reasons that we've been talking about, that saying things like Ms. Abrams is SLAPP happy and a bully, and she goes on attack in court.
SLAPP happy?
SLAPP happy.
SLAPP happy?
I'm sorry, seal happy.
Okay.
I'm sorry.
All right.
Seal happy.
I just wanted to, yeah, that's okay.
Seal happy. Thank you for correcting me. But saying she's seal happy, having an article saying she's a bully, having an article saying she attacked a family court judge, none of those things are defamation, and this case must be dismissed under the special motion to dismiss statute. Your Honor, at some point Mr. Gilmore said, well, we don't have evidence. We need to take discovery about this agreement, this conspiracy. On the 12b-5, they need evidence, and all of this is just built on speculation, that because Mr. Schneider used some vague language that we can infer somehow from that Mr. Sanson's motivation in posting these was somehow improper is absurd. But it also really still goes back to the heart of the First Amendment, which is if Mr. Sanson, if he said, she's on my priority list, this is an issue I want to go after, there is nothing wrong with that. It's absolutely legal. If he had a priority list of public officials that he was upset with, if he had a priority list of attorneys he thought were acting badly in court, and Your Honor, the idea that we're just private people that can sue and say that we've suffered emotional distress because somebody says we seal too many court documents, that flies in the face of the fact that we're officers of the court. We have a quasi-judicial agency, the state bar, that is responsible for overseeing our conduct. And the idea that we're above public comment on things that we comment on about to each other and about each other all the time is absurd. Mr. Sanson might not be a lawyer, but he has every right to say, hey, I don't think this meets the standards for sealing. Thank you, Your Honor.
Thank you. Okay, at this time, I want to review a few things, and I'll issue a ruling by minute order. I do believe I have to deal with the anti-SLAPP motion first before I can deal with any 12B5.
Could I just
Do you-
make one,
Of course.
one brief statement?
Of course.
The-
No problem.
the
You've been so
email-
nice and quiet.
The
Your co-counsel has carried the day, so.
the email that's in question
Uh-huh.
is before the hearing. It's certainly before any of the publications, because that's what the asking withdraw the motion is part of the hearing. So to make that clear, that was sent prior to all of this.
Okay. All right. Thank you very much.
Thank you, Your Honor.
Thank you. Thank you, Mr. Potter. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you very much. Okay, is there anyone here on the 8:30 calendar? All right, so we can go right into the pre-trials. Okay, thank you. Yeah, she needs to come in here. Brian Smith versus Bradley Priotti, case A 72450.